So we now turn to a presentation by Opega Director Peter Schleck on Opega's newest report entitled Office of Cannabis Policy, Identification and Management of Conflicts of Interest in Procurement, which we all have, and as the statute said, released publicly today to all interested parties and the committee. And welcome, Director. You may proceed whenever you are ready. If you need a break, let me know and do that, but I doubt it.
Thank you, Senator Hickman, Representative Mastracchio, distinguished members of the committee. Thank you for the privilege to be here to speak to you on one of the number of very important issues that the committee has assigned to Opega to do some fact finding and get back to you. I want to just ask briefly, as I always do, can everyone hear me okay?
Yeah. Yes.
Okay. So I want to do a couple things. Typically, we do walk through the entire report, and I want to acknowledge at the outset, there are a lot of company names, there are a lot of rules and regulations, there are a lot of facts here that are very detailed and heavy. And so I just want to acknowledge right up front that it's okay to be a little confused by some of this. It comes down to a statute that the issue that was raised by Representative Boyer, I will go through a more detailed summary, but there's two parts to our report. The first is a matter that Representative Boyer raised to the committee about what he was concerned about potentially being the appearance of a conflict of interest between the current incumbent director of the Office of Cannabis Policy and a company that is under contract to do certain types of has a software for tracking and tracing cannabis. We'll talk about that. We then, as a way that Opega does, and with the committee's permission, we did a broader view of a number of the procurements. We have I think we had about, since the inception of the office, we had about 21 procurements, and we tried judgmentally to pick the ones that would sort of be the biggest dollar, biggest impact. And I think there's 5 or 6 of those. And so in the second half of the report, we talk about how we went through and tried to understand how they worked through potential conflict of interest issues in a variety of the contracts. But this did come to us based on the concern about a particular company, the director, and the possibility there was an appearance of conflicts of interest. So I'm going to start there. I'm going to read you just stop, and then I'm going to look for cues that there may be a desire for questions at that time. I will then propose to describe the structure of the report and the sections of the report, and we can go into it as much or as little as needed. There may be some areas that everyone's comfortable with, but there may be areas where a little bit more is desired.
I think, Director, I think, excuse me if I may, as we certainly have done with all of our case file review report, presentation of this report, how
to do so.
Thank you.
So if we would, and I will always try to do my best to call out page numbers.
Yes.
So if we just turn to page 3, to the basic introduction, as I said. So we will recall back on February 14th, 2025, Representative David Boyer appeared before the Government Oversight Committee and raised 3 areas of concern related to the operations of the Office of Cannabis Policy within the Department of Administrative and Financial Services. Continuing here on page 3, the GOC subsequently voted to direct the Office of Program Evaluation and Government Accountability to review one of these concerns, which Representative Boyer asserted was, and I quote, the appearance of a conflict of interest between OCP Director John Hudak and the state-mandated software company Metric. The GOC specified the following scope of work for OPEGA's review. Since its inception, how have standards and requirements been applied in the Office of Cannabis Policy to identify, disclose, manage, or mitigate potential or actual conflicts of interest in contracting activity? Consequently, as I mentioned, this report presents OPEGA's results in 2 parts. First, we address the concern regarding whether there was an appearance of a conflict of interest between the OCP director, Mr. Hudak, and the state-contracted software company, Metric. And secondly, overall conclusions, issues, and recommendations for improvement based on OPEGA's consideration and analysis of relevant policies, processes, and practices, and review of 5 procurements that occurred since the inception of the office in 2019. Now, under Maine's hybrid procurement structure, the Office of State Procurement Services within DAFS standardizes policies and procedures to ensure consistent decision-making and efficient collaboration between state procurement services and agency staff. While operational aspects of procurement are the responsibility of individual agencies, I would pause just there to note the particular circumstances here are the other agency is also within DAFS. So the Office of Cannabis Policy is within DAFS, whereas DAFS also has the Office of State Procurement Services that has a role across the government. As a result, this review focused on the Office of Cannabis Policy, as well as that element within DAFS, the State Procurement Services. Okay, results in brief. We're still on page 3. Let's go right to the concern raised by Representative Boyer. The contract we're talking about, and actually more specifically, it's a contract amendment, negotiations and executions of an amendment. The contract itself was prior to Director Hudak. It was between OCP and Metric, the state's software vendor for adult use cannabis and cannabis product inventory tracking. The original Metric contract, as I said, predated the OCP director's tenure in the position with the state of Maine, while the subsequent amendment process occurred both before and then during Mr. Hudak's tenure. At the heart of the stated concern, now this is a mouthful, so we'll go over it a couple times. At the heart of the stated concern was that the director, Mr. Hudak, prior to his tenure with the state of Maine, had a relationship at a company other than Metric with an individual who later worked at Metric at the time of the Metric contract amendment process with the Cannabis Policy Office. The other company was a company called Friedman and Koski, and the other individual was Louis Koski. The OCP director has described himself both as a friend of Mr. Koski and as a co-founder of Friedman and Koski. Friedman and Koski also contracted earlier with the state concerning cannabis regulation. To assist the reader in understanding relevant events, their timing and potential relevance to whether they gave rise to the appearance of a conflict of interest as asserted, OPEGA has documented a timeline of facts and events which begin on page 7, but we will get to that and go into it in as much detail as the committee desires. Just to get to brief items that are relevant here. Page 4, blue box right in the center of the page. In brief, and with respect to the specific concern raised by Representative Boyer, OPEGA's review disclosed The OCP director, in his own words, had never worked for, taken money from, or had a financial stake in Metric. Although Louis Koski worked for Metric, Louis Koski was not involved in the Metric contract amendment process, and the OCP director's professional relationship with Louis Koski ended over 3 years prior to commencement of the director's involvement in the Metric contract amendment process. While the OCP director, as I said, described himself to Opega as a co-founder of Friedman and Koski, he did not ever have any ownership or equity in Friedman and Koski. His role was limited to performing periodic consulting services for Friedman and Koski, for which he was compensated on a contract basis. We're going to get to the statute where those facts fit in, and because you have to apply those facts to the very specific statute in Title V, and we'll get there. Which is
Chair recognizes
Yep.
Representative Perkins with the question.
Thank you, Mr. Chairman. Just out of curiosity, before we go, is there another person named Koski involved with the company?
I am not aware of that,
So
but I will. Yeah. Go ahead.
I'm only asking because I'm just curious as to why we have a company called Freeman and Koski, which would imply a partnership. And yet this person, that's why I was wondering if you have have an answer to that, that's going to be answered later, or
Yeah.
if that can be answered at some point later.
Forgive me, Representative. It's when it was early on in this discussion, Director Hudak had said he was a co-founder, which to us implied that Mr. Hudak had a partnership, as if it was Friedman, Koski, and Hudak. And it turns out that's not quite the case. In fact, it's not the case. And so that's it. The partnership issue comes up because in this conflict of interest statutes, it would have to involve Mr. Hudak having a partnership interest or a particular type of interest.
Okay, so I mean, I guess I read it wrong. So when you say he in this paragraph, the he you're referring to is Mr. Hudak, not Mr. Koski. Is that correct, or am I wrong there?
Yes, I understand the question.
Okay.
Are you talking about that last bullet point? sir?
Right, so it
Yes,
says he did not ever have any
that
ownership.
would be
Mr.
direct,
Hudak,
yes.
thank you.
Okay,
Representative.
I don't need that other question answered then.
Yeah.
Thank you.
That clears that up.
It's one of
And I'm
those
sorry for my confusion.
sorry. It's one of those challenges when we write the reports, we keep repeating the description, and sometimes we'll just say he, and then of course we get into trouble. So thank you for that. So I'm just gonna have my statute at the ready here. So I brought the actual statutes.
I do have one quick question.
Yes,
about
Senator.
this box. How, if at all, would Opega verify any of this?
It's a most excellent question, Senator. I want to explain this in the way that I want to forthrightly acknowledge to you. We interviewed Mr. Koski, we interviewed Mr. Friedman, very, very detailed. We interviewed Director Hudak. Those were representations, all consistent from them. I did not seek a subpoena from you for corporate records or tax records or bank records or anything like that. I want to explain to you that it has to do, the reason we did not go there is because once we got to the fact that his interest would have, even if it was an interest covered by the statute, was more than the 1 year period that the statute covers. And so it would have been an important task if that was still an issue. But once we sort of established that even if he did, it's outside the realm. And I know that's a lot to take in at the moment, but in the statute, it really says you only have an actual conflict if it's you, your intimate partner, a certain type of business partner within a year prior to the transaction. And the transaction here is the contract amendment. So the fact that it was already 3 years outside, but I hear you loud and clear, Senator.
Well, that answers the question.
Yeah.
Thank you.
Okay.
Please proceed.
Thank you very much. So the statute, the relevant, we're back down on page 4. And again, the summary is just through page 6. So we'll take a breath at that point and we can see where we are. The relevant conflict of interest statute covers a prior business relationship by an executive employee. And for purposes of this, there's not really any dispute. Director Hudak is an employee of the executive branch that's covered by the statute. but as a partner or fellow shareholder of a professional services contract within 1 year prior to the official participation in a proceeding. The proceeding is the contract amendment. As applied to these facts, then, the director was neither a partner of Lewis Koski nor a shareholder in Metric or Friedman and Koski. And as we said, the role ended outside of the 1 year concern, even if it was a type of role that was covered. DAFS advised OPEGA that it has interpreted the appearance provision of relevant conflict of interest statute to only cover enumerated relationships when there is a particular financial interest, not a personal friendship. Now, at the same time, internal DAF's state procurement services training materials OPEGA reviewed in the judgment of OPEGA appear somewhat inconsistent with this interpretation and warrant further review. The internal training materials OPEGA reviewed suggested that any relationship, quote, any relationship that could be construed by the public as personal was in the realm of potential conflict of interest concern. Now, I just want to stop for a minute, but not get too far out on a limb. But what I want to say to you is, essentially, is there ever a place in this whole regime of regulation where the fact that you know someone personally is the consideration that would cause you to not want to participate? I can tell you in this situation, the training materials seem to be broader in scope. That was sort of interesting to us. And so we'll keep talking about that, because it's going to come down to, also, you will see as I go through this, there was a point in the road, there were at least 2 points in the road where the legislature could have amended or had under consideration information about the statute where it was a little more, we wanted a little more than currently is in there, and it wasn't enacted. And so again, this could be an area where the legislators want to think about it in light of these developments. But I just want to explain, it again comes down to that statute. So DAFS is saying that it really has to be a financial, not just a personal relationship under the statute, which we're going to get to. DAFS advised as to the training materials that the broader description of potential conflicts of interest in the materials is to encourage open discussion that raise possible scenarios that can then be evaluated for identification or dismissal, whether it's an appearance, potential, or actual conflict. Now, as I said, the OCP director has described Lewis Koski as a friend, in addition to having had a contractual business relationship. OPEGA observed a lack of clarity regarding whether any non-financial connection that might raise questions about an executive official's impartiality could ever be considered a conflict of interest. As I said, prior relevant proposed legislation on appearance concerns was seemingly more prescriptive but never enacted, raising the possibility that the legislature may or may not wish to revisit this area. And I have some of that in Appendix F if the members are desirous of going there in a bit. Now, late in our fieldwork, DAFS produced an email which was sent by the OCP director, that's Mr. Hudak, prior to him becoming the director, to the official who would become his immediate supervisor, which is DAF's Deputy Commissioner Anya Trundy. In the email, the OCP director wrote in part, "While I have worked with someone who is now an employee at Metric, I severed a working relationship with him prior to taking his post." Now, at footnote 5, we point out it doesn't actually say the man's name in the email. We are presuming for purposes of this email that that's who is being referred to. But we will get into, as much as you would like, what is this email? Is this a disclosure? Is this not a disclosure? Was it even required? We're going to go through all of that again as we talk about it. But I just wanted to explain to you that you will see in the agency response that they cite this as a type of disclosure. And that is something I would like to talk about with you just a little bit. Now, I am the first to admit, hopefully not the last, that OPEGA is not in a position to ever render an authoritative legal opinion as to what the law in this state is. There are others for that, but we do generally acknowledge that at least the facts as we've gathered them do not support a conclusion that disclosure by the OCP director of the prior relationship with Louis Koski, or what's known as abstention, which is essentially, I'm going to not participate in this matter, was somehow required in the statute as we have it. Now, I want at some point to actually go through the statute with you, but I hate to keep teasing that, but I want you to see what is actually in the statute and what is not. So we're going to get there. But then for a variety of reasons, and we set forth all of this in the second part of the report, OPEGA nevertheless did conclude that DAFS should seek to enhance its policies to provide better guidance for these matters. Greater clarity and rigor in DAF's state procurement services procedure, particularly as to the importance of roles and responsibilities in documenting conflict of interest disclosure and abstentions, should be pursued. And OPEGA acknowledges DAFS is in the process of doing just that by creating a formal written policy, which was provided to OPEGA in draft toward the end of our work. So that is a summary, a very summary level as to the particular issue that brought us here. I want to just turn to page 6, and then we're going to stop and see where we are. But I want to give you a flavor of page 6, which really was looking at more than just this contract, looking at 5 key contracts out of the 21. A lot of them, not that they're not important, but these, I'll show you later in the document. These are sort of ones that were pretty relevant to this type of transaction. So page 6 at the top, overall conclusions, issues, and recommendations based on our review of the 5 procurements and consideration of current statute and DAF's policies and procedures. So we considered the current statute, DAF's policies, practices, procedures, and reviewing the 5 procurements. As a result, OPEGA concluded the following. There was no clear formal written policy within DAFS outlining how a potential conflict of interest should be disclosed or managed in relation to OCP contracting activity. There was a lack of adequate documentation of potential conflict or actual conflicts of interest in instances in which such matters were identified and disclosed. The absence of an adequate written record can inhibit later review and assurance that such matters were handled appropriately. Those 2 points said, in terms of our walking through the 5 contracts and looking at the process as it is required, OPEGA, we do acknowledge, found that OCP considered conflicts of interest at several points in the process that we reviewed, and they did comply generally. I can show you later, there's an example where they missed something that was a sign off on somebody making a disclosure, but generally speaking, they did what was expected under the current regime. Now, we have recommendations, and we'll go into this. We want them to provide clear, thorough, formal guidance to agencies. I mentioned to you, you have the statute and the opinion of DAFS that really it's only financial. It has to fit into the financial stuff for it even to later be a possible appearance. Yet when you look at their training materials, it just, if I were sitting there trying to understand, what do I do? I would have a little bit of a lack of clarity there. And so I think there's opportunities here for greater clarity. So provide clear, thorough, formal guidance to agencies, including OCP, which is an agency, if you will, a part of an agency, on how to identify, disclose, manage, or mitigate potential and actual conflicts of interest through contracting activities. We believe such policies should include both state procurement services and agency roles and responsibilities regarding requirements for documentation and records retention of disclosures of conflicts of interest and abstentions from contracting activities based on actual or appearance of conflict. Now, in response, you have their letter in the back, which they can speak to. But during the review, in response to all of this, because we're having an ongoing dialogue as we develop our findings, they told us the following. Now, some of this is just a little inconsistent with the agency response in the back. And I just want to make sure when the agency comes before you, that you have an adequate understanding of what is it they're saying they agree with and what is it they're saying they disagree with. Because during the review, they said they shared with OPEGA draft documents seeking to formalize the previously unwritten approach to handling conflict of interest inquiries, and I'm using quotes here, and some enhancements suggested by the Office of the State Controller and the relevant Assistant Attorney General. that they recognized the need for a more structured and transparent process, and that they indicated that components of the draft policy will include, now this is their list. This is their list. You'll see later in the agency response that they say a form is completely unrealistic for this process. Opaque, I've looked through again, and I don't think I missed it since I was part of this process. We never said they had to have one form for something. So I'm not sure what's up with that, but I wanted to highlight to you, there are issues in the response that are a little inconsistent with this. So I didn't want you to think we just, it is what it is. Okay. So in terms of the components of the draft policy, which they say they need, which they do believe is worthwhile, they do believe a formal written policy outlining conflict of interest inquiry processes when these issues come up, clearly established agency and staff responsibilities, and internal conflict of interest reporting, there's that word again, form. This is what they wrote to us. Integrated SharePoint functionality to support tracking, shared documentation and visibility, and additional updates and clarification based on input from the state controller and the relevant assistant attorney general. So I want to stop there. I think we understood ourselves to be on common ground that there were opportunities here where if I were someone going through the process, I might not be crystal clear based on our own review as sort of outsiders. When do I need to be worried about this? What are the prompts that prompt me? Part 2 of the report, which we can go over, is there are a number of points along the road where people who participate in certain aspects of the procurement process are prompted and do check off certain things that, yes, I don't have a conflict, etc. But then there are other people who maybe it's not quite so clear when they put that into motion, who they talk to, how they talk to, whether it's documented. There is it seems like a disagreement by DAFs with us. We think it's particularly important. So take the current case. It appears like Director Hudak sort of made a disclosure, at least that the department thinks was somewhat of a disclosure. I don't want to speak for them, of something that turned out not to be required and not to be an issue under the statute. And yet Opega believes that should all be kept. That should all be in the file somewhere appropriate. So when these questions or controversies come up, they should be, let me put the words that we use in the report, readily available. I think that showing that contemporaneously in time, the issues were considered appropriately. And again, how exactly, how, when? The lack of a written policy that actually spells out when, I think has the potential to contribute to concern and controversy. How are these things being handled? Well, if you have a nice, crisp policy, you or I don't necessarily have to agree that something was or wasn't a concern, but at least if you can show everyone, here's the process, that just seems to make a lot more sense, at least to Opega. DAFs has their opportunity to appear before you and explain if I'm misunderstanding the nuance here. So I did want to stop there, Senator, and I wanted to say I am more than happy to take any detailed questions, talk to you about the structure, go through it in detail. It's possible some of my answer will be, well, let's go to that section, or, so just happy to take anything.
Thank you. Are there any questions so far from the committee? I think I would appreciate it if you just keep presenting the text.
All right.
And anything you'd like to say
Sure.
about it. And if there are any questions along the way, as we've already had, we will ask those and interrupt you to do that. But thank you very much.
Very much appreciate the opportunity to be of assistance here. So if we let's go through back to part 1, which was the concern that Director Hudak potentially had an appearance. And I don't mean to quibble unnecessarily with the DAF's response in the back, but there is a flavor in it, I must observe, about, and if I'm over-interpreting it, you can read it for yourself. Just the idea that, well, this was obviously not an issue from the beginning. I'm not prepared to say that because we didn't know the facts and these nuances. And when Director Hudak says he's a founding member of something, one could not understand that maybe there is something there. So I want to say the fact-finding process, I would hate to have anyone say was not necessary here if there were sincere concerns. by folks. So let me stop there and keep going. So this is essentially a timeline. I'll try to walk you through it. Page 7, just about Director Hudak. Going back to prior to his appointment as director of the Cannabis Policy Office, Director Hudak, Mr. Hudak was employed at the Brookings Institution for about 10 and a half years. That's 2013 to 2022. While at Brookings, Hudak also worked as a consultant. According to Director Hudak, in 2017, Hudak co-founded, there's that word again, Friedman and Koski, a cannabis consulting firm with Andrew Friedman and Louis Koski. Director Hudak advised Opega that he did not, however, have any ownership or equity stake in Friedman and Koski. Andrew Friedman and Louis Koski each had 50%. That's 100%. Nor was he a salaried employee of Friedman and Koski. Rather, Hudak worked on a contract basis for specific projects. Director Hudak remained on a contract basis until 2022, although by that time, as described below, this Louis Koski had actually left Friedman and Koski. Director Hudak again told Opega he also maintained a friendly relationship with Louis Koski over time. So again, I'm just mentioning this notion of when, if ever, is that a consideration in this type of process? It's not a financial interest, but there's a potential friendship or something. Okay.
And may I ask a question?
Yes, Senator.
I don't see it in the timeline here. Maybe it's something that you can look at your records for.
Sure.
The consulting contracts that Mr. Hudak performed on behalf of Friedman and Koski in the time that he was affiliated, I'll use the term affiliated with them. Did you inquire or know if any of that consulting work had to do with the regulations for the current program that Friedman and Koski worked on for the Office of Cannabis Policy under the previous director, I should say, the first director?
Thank you, Senator. There is a footnote
Okay.
that goes into that. And I will find it for you.
Okay, no worries.
I may not have it this second, but I know there's a footnote that I highlighted, and I will get to that at some point as we encounter it.
Perfect.
Footnote 32.
Thank you.
Page 13. Director Hudak, Mr. Hudak he participated in a site visit by Friedman and Koski in Maine to discuss a federal policy update and discuss in-state stakeholder outreach strategy. Hudak did not conduct business with Friedman and Koski with the state of Maine after the work related to the December 2021 visit. So that's what we were able to
Thank you.
come up with. I appreciate very much, again, why that would be a question of interest. So we're back on page 7, and it's Friedman and Koski's contract with the state of Maine. So we're not talking about Metric. We're talking about this other company, Friedman and Koski. And I want to explain, as described to us and as we understood it, Friedman and Koski was primarily a government services firm focused on developing and implementing cannabis legalization policy for the medical and adult use components of the cannabis industry. And I know I want to also acknowledge Senator Hickman, Senator Timberlake, members of VLA are certainly well-versed in all of these issues. So I didn't mean to presume that you didn't already know all this, but anyway, so.
There are more than us on this committee.
Yes.
And there are more than us listening. And
yes,
so.
Understood. So, but the first contract by Friedman and Koski, fall of 2018, prior to the inception of even the Office of Cannabis Policy, when DAFS awarded Friedman and Koski what was an emergency sole source contract for emergency rulemaking in response to a particular public law, an act to amend the Maine Medical Use of Marijuana Act, which required DAFs to adopt rules governing cannabis manufacturing facilities. Subsequently, DAFs posted a request for proposal for rulemaking pursuant to another piece of legislation, an act to implement a regulatory structure for adult use marijuana, and also 1539, LD 1539, an act to amend Maine's medical marijuana law, which was also ultimately awarded to Friedman and Koski, the same month that the Office of Cannabis Policy was officially established. The contract with Friedman and Koski ultimately ran from March 2019 through March 2022. At the beginning of the contract, Louis Koski, so he's with Friedman and Koski, he then joins Metric as chief operating officer. This was during an approximately 3-month transition period, apparently, in which Louis Koski was winding down his work with Friedman and Koski while working at Metric. And by late summer 2019, Louis Koski had fully divested from Friedman and Koski. Although Andrew Friedman, the other name in Friedman and Koski, never officially changed the name of Friedman and Koski following Louis Koski's exit, Opega was told that Andrew Friedman did refer to the firm as Andrew Friedman Consulting. Eventually, Andrew Friedman began a separate new venture, Cannabis Public Policy Consulting, which we get into for certain reasons on page 12. So there's a bit of an evolution there of the Friedman and Koski firm to Andrew Friedman Consulting that then becomes Cannabis Public Policy Consulting. In February 2019, the newly established OCP also announced an award with Metric for a cannabis seed-to-sale tracking system, piggybacking off of a competitive bidding process in Alaska, which is apparently a thing. That's apparently a thing, which we explain in a footnote there, page 15. So, however, this contract was not ultimately executed, and DAF's OCP instead conducted a competitive bidding process, launching a new request for proposal. So then in March 2019, Louis Koski joins Metric as chief operating officer. During September 2019, the seed to sale contract was awarded to, actually, here is another company, BioTrack. OCP and BioTrack began rolling out the new system. However, by December 2019, OCP announced that the contract with BioTrack had been mutually terminated. Rather than further delay the rollout of the adult use cannabis market by restarting the RFP process, OCP announced that they intended to go with second place bidder Metric. The Office of Cannabis Policy and Metric agreed to contract terms in February 2020. The contract was for $540,000 running from February 5th, 2020 through February 4th, 2026 for a commercial off-the-shelf tracking system.
Yes, the chair recognizes Representative Mastracchio with the question,
Thank you,
and then
Mr.
I have a statement about.
I'm just really confused. And I guess it's like, why? So in December 2019, OCP announced that the contract with BioTrack had been mutually terminated. Now, it had been in place from earlier in the spring, right? And then they mutually terminated it, and then, but they need to do something because they've got to implement. But how does that just happen? I mean, what kind of process lets that happen, and who do they report to? And I'm just curious here. Because it seems a little odd when you're spending, the taxpayer money for things like that. I'm just really very confused.
This is a question that's a most excellent question, and I appreciate it very much. We could maybe do a whole review on just that issue. We did not, that information, even, this is something that I guess I would start with. My best answer is always, if we could save this one for the department when they come up. I am not completely clear, and I always hesitate to say this to the committee. I am not privy to all of the ins and outs of that. Even if I was, I have some questions about what's procurement protected information under certain situations. And I just don't want to stumble here. I want the department to answer to you. If there's a public reason why that happened that they can share with you, then I would like that to happen.
You may proceed.
So they were paid, though. The first company was paid for the time that they were doing it. Then the contract's done, and then there's some money left, I guess, and it's going to somebody else. Is that just to ask? I mean, when you get that information that says that that was mutually terminated, I'm assuming that you try to delve into it deeper.
Again, we did not. I'll be the first to acknowledge we did not. But I absolutely understand why that would be a question you would want DAFs to answer or tell you why if they say there's some reason why it's sensitive internal procurement, something.
There
Yeah.
was controversy about this at the time in the industry, not necessarily in the legislature. And I am not sure how that went.
Yeah.
I thought, if I remembered correctly, that when Representative Boyer presented his timeline to the committee, there was some accusation by someone at BioTrack that the termination of the contract represented a different kind of conflict of interest. And we can verify that because that's already in the record, but that's just my memory talking. The other thing that I wanted to just put into the record, which isn't in the report, is that Mr. Friedman of Friedman and Kosky, and now Cannabis Public Policy Consulting, when the legislature was considering the new statute that would replace the statute that was approved by the people, Mr. Friedman was the cannabis czar in Colorado, which I believe had launched one of the nation's first adult use cannabis markets. And he, in that role, consulted with our committee, which I was on at the time, the Marijuana Implementation Legalization Committee. He was a frequent member of the experts in the public who helped us draft that legislation, and consulted very much with the chairs of the committee at that time. So Mr. Friedman's involvement in cannabis legalization in Maine goes all the way back to even before we authorized the statute and created the Office of Cannabis Policy. So, Mr. Director Hudak, please continue.
Thank you, Senator.
Director Slack, please continue.
That's quite all right. Thank you, Senator. And I don't want to even make it more complicated, but I passed over a footnote about when Friedman and Kosky, when there was the contract originally for Friedman and Kosky, there's this other company that sounds an awful lot like BioTrack, that's Botec.
Oh, that's
which
who I
isn't-
was talking about.
That's who you were talking
There we
about,
go.
Senator. So, but I completely understand why that, because I had the same issue. So I just want to explain again what I said at the outset, which is it's okay to be confused because there's a lot here. It doesn't roll right off the tongue. I mean, so we're one of the things that we hope we've provided here is to really lay out the public accounting of who's who, what's what, and how it rolled out. Okay, so rather than delay that rollout, as Representative Mastracchio said, they went with the second place bidder, which actually was Metric. Now, they got the contract. So then batch tracking, as those many of you know, batch tracking legislation, and then there was this Metric contract amendment, and I will explain here on page 9, middle of page 9, the blue heading there. During the 130th legislature, the Joint Standing Committee on Veterans and Legal Affairs considered legislation that proposed to implement batch tracking. Batch tracking, as footnote 18 explains, refers to the requirement that cannabis plants at the same stage of growth that are the same varietal or cultivar of the plant genus cannabis may be tracked by group if they meet certain criteria. So, back up here. This legislation was enacted and became effective in August 2022. Early in May 2022, Louis Kosky, who had been Chief Operating Officer at Metric, moved into a new role as Metric's Chief Strategy Office. In this new role, Louis Kosky was focused solely on international opportunities. In the summer of 2022, the prior Office of Cannabis Policy Director, to be clear, a man named Mr. Gunderson, began the contract amendment negotiations with Metric. That's the amendment that had the appearance concern we started with, as articulated by Representative Boyer. So the negotiations begin with Metric by Director Gunderson, prior to Director Hudak, to implement the new batch tracking requirement. Director Gunderson and Metric previously agreed to terms of the contract amendment, and Director Gunderson delivered the proposal to DAF's leadership in October 2022 as he was exiting. DAF's leadership, however, determined that the terms were not favorable to the state and did not move forward with the proposed contract amendment. Instead, DAFS reached out to a former employee, Mr. Thompson, who was previously the state's procurement officer and state chief information officer, and had recently retired from the deputy commissioner role at DAFS. Thompson was brought back in to help with the contract amendment, restarting the conversations with Metric.
So Director, this may be for the department, but
Sure.
I'll ask you anyway. Is that proposed contract amendment that was rejected by DAFS anything you saw, or is it confidential? Or, I mean, you can see confidential, but I'm just curious as to
I will
what
get
was
you.
there
Thank you, Senator.
that wasn't good for the state.
I will get you clarity on whether whether a member of the team actually laid eyes on it or whether it was something that it's one of those issues that we might have considered, but we would be going down a different, but these are things that at any point we can,
I think the
follow
reas-
up on.
The reason why I ask
Yeah.
is because, and this will be fleshed out a little bit more later, I suppose, is that to the people in the industry, less the committee, because I didn't even know about this, but to the people in the industry who have more of an opinion about who's doing what and where and why and how, were concerned that the ultimate contract with the state was far too friendly to Metric, to the detriment of industry participants. And I'm just wondering if what this looked like instead of that. So that's the reason why I asked the
Great.
question.
so if with the chair's blessing, we'll put that on the list
Mhm.
for the chair to ask when DAFS comes up. And then if there's any further, we can always follow up for the public hearing.
Yeah.
Okay, terrific. So, during Director Hudak's hiring process, that's page 9 at the bottom. Taking you to early December 2022. Director Hudak informed Deputy Commissioner Anya Trundy, who would become his direct supervisor via email, that he had never worked for, taken money from, or had a financial stake in Metric. And that while he worked with someone who was now an employee at Metric, he had severed his working relationship with that person prior to that person taking the Metric position. Although not specifically named in the email, this person is presumably Louis Koski. Director Hudak was appointed as Director of OCP effective December 30th, 2022, and was informed that negotiation of the Metric contract amendment would be a top and immediate priority. Between January and March 2023, OCP and Metric negotiated the contract amendment. Director Hudak relied on the knowledge and experience of Mr. Thompson. OCP and Lisa Roberts were also involved in the negotiations. Metric employees involved in the contract negotiations included Metric's Chief Financial Officer, Chief Technology Officer, Chief Legal Officer, Senior Vice President of Growth, Customer Service, and Vice President of External Affairs and Business Development. Opega did not observe any evidence that Louis Koski was involved in the contract amendment negotiations, nor any evidence to indicate that Director Hudak's relationship with Louis Koski influenced the contract amendment negotiations. The contract amendment was signed by Director Hudak on March 31st, 2023, reviewed and approved by the Director of IT Procurement on April 3rd, 2023, and reviewed and finalized by State Procurement Services on April 13th, 2023. The amendment adjusted the contract amendment by $350,000 for a total of $890,000, but kept the expiration of the contract as February 26th. Okay, so now let's get to this actual statute on page 10. So the first section, I'm just going to introduce this to you. There's a section I'm going to read to you, which is essentially, it's not even described as such, but we presume, and the Office of the Governmental Ethics Commission presumes, I'll explain, that these are essentially what are the statutorily enumerated conflicts of interest. Then there's a subsection further down, that's section 7, that talks about avoiding the appearance. Okay, so 5 main revised statute 18 parentheses 2 prohibits executive employees from participating in certain proceedings, including contracting. So we're just stipulating this is Director Hudak is an executive employee. this contracting is a proceeding within the meaning of the statute, in which they have a direct and substantial financial interest. And subsection 7 of that statute requires executive employees to endeavor to avoid the appearance of a conflict of interest by disclosure or abstention. At the same time, the statute does not define what constitutes an appearance, nor does it include a definition of the term conflict of interest.
If I may,
Yeah.
does it define direct and substantial financial interest?
I will say this under advisement that I will always correct myself if I have somehow skipped over something, but in terms of section 18, it defines, this is Title 5, section 18. In section 1, subsection 1, it includes who are the constitutional officers, that's defined, who are executive employees, that's defined, participate in official capacity is defined, proceeding is defined, and participates in the legislative process is defined. So the answer I give you as firmly as I can is no.
I didn't see it, but I
Yeah.
wanted to know, and I don't know if there are any rules on this where something could be further defined. But there's no definition of direct and substantial financial interest, nor is there any reference to an indirect financial interest, which is in many other places in statute. It's all over the liquor law. And so this just may be, notwithstanding this particular situation,
Yes.
this conflict of interest statute may need review
Yes.
because it doesn't seem comprehensive enough at the outset of this conversation that we're having.
And I would respectfully say to the chair, there may be a number of situations as we go through the actual terms here that cause the chair to say, is this statute all that it can be?
Right.
Okay. So that's that. So now, in the terms of the statute itself, it says, and this is the blue box on page 10, an executive employee, that's Mr. Hudak, commits a civil violation if the executive employee personally and substantially participates in an official capacity in any proceeding in which, to the executive employee's knowledge, any of the following have a direct and substantial financial interest. A, the executive employee or the executive employee's spouse or dependent children, the executive employee's partners, a person or organization with whom the executive employee is negotiating or has agreed to an arrangement concerning prospective employment. D, an organization in which the executive employee has a direct and substantial financial interest. Or E, a person with whom the executive employee has been associated as a partner or a fellow shareholder in a professional services corporation pursuant to certain other provisions of statute. So you see, that's that 1 year.
During the proceeding.
Yeah, and we're in a 3-year.
Yep.
So whether that statute should or should not be amended is up to the legislature. But in terms of where we land, that last section, subsection E, it's only the year prior.
Right.
Okay. Now that's what's actual. So as we said, DAFS has asserted to OPEGA that the test of a conflict of interest is financial benefit to the employee, and therefore an appearance of a conflict of interest requires the appearance of a financial benefit. In other words, down further, there's a section 7 that says also endeavor to avoid the appearance. Well, what does that mean? DAFS is interpreting that as it's not even an appearance if it's not an appearance that you have a financial interest. I'll get to this further. I don't mean to jump around on you. We only found one attorney general opinion interpreting this. And I'm not saying it proves anything decisively, but it did involve an actual person in government who owned land next to the turnpike interchange that was going to be built.
Mhm.
So it was the one example we could find in interpretive guidance actually was a financial interest.
Yep.
Okay. So DAFS has stated their position. and therefore asserted that Director Hudak did not have an appearance of conflict of interest. I think I mentioned this earlier. The Maine Commission on Governmental Ethics and Election Practices had a report on ethics law for executive branch employees. It's a little old, but it stood the test of time. We're on page 11. Presumably, the activities forbidden, as noted, this is them saying this, presumably the activities forbidden in that section I just read you, as well in those in a couple of other places regarding to folks participating in the legislative process, and if you're a former executive employee, those two areas don't really apply here. But that those things specifically listed are intended to constitute a conflict of interest. They're not referred to as such. As we said, the definition, it's not there. By this interpretation, one could conclude that an appearance of a conflict of interest constitutes only an appearance that the executive employee has a direct and substantial financial interest in the proceeding as prohibited by the other section. As I said, OPEGA is not in a position to render an authoritative legal opinion. We are aware of one Attorney General opinion which asserts certain underlying principles to preserve and protect public confidence through the lens of transparency and accountability. Preserving public confidence in agencies and institutions lies at the very heart of the requirement that executive employees endeavor to avoid the appearance. This provision is intended to send a clear message to executive employees that they should be alert to the need to evaluate their actions. Well, again, as we'll discuss a little bit more when it comes to DAF's training materials, which actions, when, how, what. Okay, that brings me right to DAF's training. We reviewed the training on ethics and procurement process conducted by DAFs and state procurement services and available on their intranet. The training, like best practices literature we reviewed from the National Association of State Procurement Officials, covers not only those situations in which there may be an appearance of a financial interest, but also those situations in which there may be an appearance of other types of potential for conflict. In this regard, the training covers situations beyond the statute we've been discussing. In contrast to this statutory scheme, their own agency ethics training defines a conflict of interest as when a public official has a private or other interest that influences or appears to influence the impartial and objective performance of his or her duties. And examples include a close relationship with a bidding company, economic interest in a bidding company, prospects of future employment with a bidding vendor. This guidance appears to be much broader in scope than the statutory limitations already discussed. Again, we consulted best practices literature. And best practice may be to identify anything that could potentially, this is on page 12 now, anything that could potentially be perceived by others as a conflict of interest or even the appearance of a conflict of interest for consideration and resolution by others in the chain of command. The state must balance ensuring that the state is getting the best services for the best value while also ensuring public trust in the process. So, the relevant appearance statute does appear to recognize the need for this balance by explicitly disqualifying executive employees from certain proceedings in which there is a direct and substantial financial interest, or in the specific case of contracting activity, a direct or indirect pecuniary interest. As best we understand, pecuniary and financial in this context, notwithstanding general rules of statutory construction, pecuniary here is financial. So, but again, Senator, that's another area where just I point that out. So there's a couple of ways to just resolve the concern. One, situation may present an appearance of a conflict of interest, but does not require disqualification. So even if it is considered an appearance that you don't have to disqualify, you can resolve it by disclosing that the relationship exists. All right, so then we go through again, page 12, the specific facts as applied to the specific statute. We have seen those. I have already stated those to you. Now, not to add to your confusion, but if you recall the evolution of Friedman and Kosky to Andrew Friedman to what? Cannabis Public Policy Consulting. Here's something that pops up on Director Hudak's financial disclosures, where he did have a financial interest in Cannabis Public Policy Consulting because he was being paid at a certain point. So this is why we mention this to make sure there's a fully inclusive record here. Page 12, in contrast with the circumstances surrounding the OCP director and Metric, the following is a demonstration of how an appearance of conflict of interest was handled when the OCP director had a prior financial relationship with another vendor. This is the ultimately evolved Cannabis Public Policy Consulting. We sought information on the nature of the relationship between Director Hudak and CPPC to understand how and why the potential conflict of interest was identified and disclosed, and how it was ultimately managed or mitigated. Through interviews, review of relevant contracts, director's annual financial disclosures, we were able to identify the following facts. Now, this again takes you down a history, and I apologize for all the different companies, but essentially, if you go back to Office of Cannabis Policy, they began contracting with an entity that was known as Advocates for Human Potential. You haven't heard that name yet. In the spring of 2020, for data collection and analysis on the effects of the use of cannabis in Maine. That entity, AHP, had previously worked as a subcontractor under OCP's contract with Friedman and Kosky. After Louis Kosky left Friedman and Kosky, Andrew Friedman began a joint venture with the owner of AHP, launching Cannabis Public Policy Consulting. CPPC, as it's known in shorthand, used AHP for back office support and bookkeeping, and some personnel who contracted with Friedman and Kosky and/or AHP also contracted with or ultimately received payment from this new entity. This includes OCP Director Hudak. He was compensated for certain work by OCCP prior to his appointment. Director Hudak's last work for CPPC occurred in 2021, for which he was paid in 2022, and for travel reimbursement for a one-day conference in early December 2022. Director Hudak started with OCP on December 30th, 2022. Accordingly, Director Hudak's financial disclosure for 2022 identifies CPPC as income from self-employment. In December 2023, Director Hudak learned from his staff that OCP, so now he's the director, he learns from his staff that Cannabis Policy Office contract with AHP and CPPC was set to expire in April 2024, 4 months away. OCP anticipated posting a new request for proposals for market analysis for which CPPC was a likely bidder. Accordingly, the same day that Director Hudak was notified, he emailed his direct supervisor, Deputy Commissioner Trundy, that given his previous work for AHP CPPC, he was fully recusing himself from that contracting activity and directing that all conversations or actions related to that contract should run through his deputy directors. So here is a case where he was getting money from CPPC prior to his tenure, and he did disclose it and he did recuse himself. The twist, though, is that Director Hudak was not required to disqualify himself pursuant to criteria listed in 18(2). Director Hudak believed that his prior financial relationship could raise, with that word again, the appearance of a conflict of interest. Consistent with requirements, Director Hudak immediately notified his direct supervisor and abstained from these proceedings. But again, there was a financial interest there. That is a lot of stuff to say. Basically, we have the statute. I invite you at your leisure or in questioning me to go back as many times as you want to the statute, which includes the specific examples where there's essentially an actual conflict, and then there's this notion of what an appearance is. I would say again, though, that it's not very detailed. If I'm looking at 5 MRS section 18 parentheses, sub parentheses 7, every executive employee shall endeavor to avoid the appearance of a conflict of interest by disclosure or by abstention. For the purposes of this subsection and subsection 8, disclosure, conflict of interest includes receiving remuneration other than reimbursement for reasonable travel expenses for performing functions that a reasonable person would expect to perform as part of that person's official responsibility as an executive employee. Includes. It doesn't tell you whether it's an objective test, a subjective test.
Mhm.
You may look at it and you may say, this seems like a concern. Representative Boyer may look at it and say, it seems like a concern. Members of the public may. So this is another area I just mentioned to you, to the members of the committee. There's not a lot of definition there around you kind of get there if you follow the interpretation of DAFs, if you do, and then you have the ethics commission, you kind of make certain presumptions. But it doesn't really say what is okay, thank you.
Well, I mean, I think that as we have talked about other
Yeah.
procurement issues, especially with the single audit report, we hear all the time from folks in the atmosphere that there are all these conflicts of interest in these contracts because someone might be related to someone who might be related to someone, but the law doesn't say that that's a conflict of interest. And
Right.
so there's what people understand as a conflict of interest,
Right.
and then there's what the text of the law says. Back to the report.
Yes, Senator.
Did the Office of Cannabis Policy in fact extend this marketing analysis contract with CPPC that expired in April 2024?
I think I have the answer to that, but I would invite you to direct that directly to make sure there is no confusion on my part, that you're getting that answer direct from the department. Thank you.
All right, we are now on part 2.
We're on part 2. And as I said, I am here to do what the committee wants, chairs. I will continue as such, but I appreciate this is a lot of information. It's very dense. That's not to rush you along either. I'm here as long as you
It's
want
what
me
we
to.
do. We do depth.
Understood,
And
Senator.
the thing is that this is the issues of procurement go above and beyond the
Yes.
case that we're looking at.
Yes,
And so it's very important to have
Yes.
all of this detail into the record for our consideration and for the consideration of the public who can participate in a public hearing on this
and
in an upcoming meeting.
and thank you, Senator. If you'll indulge one quick point.
Excuse me, if the committee is in order, I do want to do one
Oh,
thing.
yes,
I want to allow Senator Dusan to introduce herself since she came in during the last part of our discussion, and then I'll call on Representative Perkins for the question or comment.
Thank you, Mr. Chair. Thank you, everyone. I have arrived late from a prior engagement at pretty early this morning in Booth Bay. But I'm pleased to be here for this part of the presentation. And thank you very much. I am Jill Dusan. I represent Senate District 27, which is part of Portland and part of Westbrook.
Thank you. Welcome. Chair recognizes Representative Perkins.
Mr. Chairman, thank you. Real quick, before we move on to the last section, I just wanted to address the comment the director made and ask him a question. You said that the director was not required to recuse himself under Title V, Section 18, subsection 2. Is that because, and I noticed it was a year period there, is it because subsection E, because he was not a shareholder or in the corporation that he was dealing with? Is that the portion that makes that relevant?
I was nodding, but I will say for the record, yes,
Okay.
you are correct, Representative.
Right, thank you.
Thank you. Okay, part 2.
All right, so here are the contracts we looked at, which we thought would be reasonably representative. It's a judgmental sample. It's not any super scientific formula. These were the ones we thought would be reasonably representative if we put them through the process of looking at where along the road does the agency consider conflicts of interest in the advertising, the negotiating, the reviewing proposals, and the award. So in order, again, this is page 14. in order to also assess how statutes, policies, and practices have been applied systemically at OCP to potential or actual conflicts of interest in the procurement process over time. We conducted a detailed review of 5 procurements that occurred since the inception of the office. And just to anticipate a question, I think I mentioned this, I think there were about 21 procurements that we could have picked. We really feel like these were ones that would give us a representative view of how they're doing it. Also the most significant dollar amount contracts. So I think that's always an interesting piece of it. And these go back to the inception of the office. So
My question's answered.
very good.
Please proceed.
We are very good, Senator. So there are key parts of the RFP that you're familiar with this. Oh, and Senator, if this chair will indulge me, I did want to say one thing about future attractions and also this case. For those who weren't on the committee, those who were and those who weren't, those who were will remember in the last session, the last legislature, that this committee began a journey of looking at procurement writ large, and that it is sort of the intention of this process here and in Juniper Ridge and in the daycare payments to give you case studies in addition to the specific issues relevant to those cases. As you said, Senator, this will give you the opportunity to see larger potential connective tissue or issues of interest. So
Correct.
so in that sense, I just use that word case study. So we reviewed the existing policies. There are key parts of the process on which agency staff is trained and prompted, that's a word I use, prompted to consider potential and actual conflict of interest. Agency staff, however, are also expected to identify potential and actual conflicts of interest of which they become aware during all phases of contracting activity. This expectation is not formalized in a written policy. Underline that. This expectation is not formalized in a written policy. So we reviewed what there was along with interviews to understand additional expectations that have not been formalized. We reviewed the procurement materials related to these 5 contracts to determine whether policy and expectations were met related to conflict of interest. We looked at any other evidence that conflict of interest were considered during the process. We note that DAF's state procurement services requirements related to conflicts of interest have changed over time, and we took that into account as we assessed the materials between 2019 and 25. Overall, this is the headline in terms of just looking through how they do what they do in existing process. We found that OCP considered conflicts of interest at several points in the procurement process that we reviewed and complied generally, underline that because I'll explain, with current applicable requirements. We then go through sections where we talk about their process. I would like to highlight for you, I mentioned to you there's this issue where the interpretation for the current matter of concern with Director Hudak, the statute says what it says and that's it. And OPEGA is not here to disagree with that. But then we look at the internal training documents and there's a video that they show, and it talks about examples of potential conflicts. And one of them in those 3 bullets, this is the middle of page 5, that there is a personal contractual relationship with a bidder, or we put this in italics for obvious reasons, or any relationship that could be construed by the public as personal. That's very broad. And we're not here before you to say that that should be the standard, by no means, because we know Maine, we love Maine, and everyone knows everyone. And so I believe me when I say we're not here to tell you that's the standard, but we think this training, this material maybe needs a little look-see, because what are you telling the employee? What are they supposed to be worried about, and how? And how do they work through that in the system? So, so there's the RFP process, and there are clearly process by which if someone on the evaluation team, this is when bids are received, if they are concerned about a potential or actual conflict of interest, they are directed to contact the RFP coordinator immediately to discuss those concerns. Now, the RFP coordinator, OPEGA notes that the statute requires executive employees to disclose immediately to their direct supervisor any conflicts of interest, while the OSPS training directs employees to contact the RFP coordinator, who may not be the employee's supervisor. Not to put too fine a point on it, but again, we have these issues where there seems to be some language that could stand to have a look-see. Should a conflict of interest be identified that requires disclosure under the statute, it is important that agency staff are instructed to make the disclosure to their direct supervisor in addition to the RFP coordinator. Now, while there is no mandatory ethics training for agency staff who are not part of the evaluation team, there is an ethics training video that is available on their intranet, State Procurement Services intranet, that includes a robust discussion of conflicts of interest. State Procurement Services informed OPEGA that agencies can request ethics training from OSPS, but that such requests are uncommon, especially now that the video is available. They are working, you'll see in footnote 36, they're working on an updated training module and is expected to be released in the third quarter of FY26 in conjunction with State Procurement Services annual conference. So the RFP teams, looking at that, if you look at page 16, we saw evidence when it came to the evaluation teams for bidders. We saw evidence that they certified they had participated in training, which includes conflict of interest training. We did note, this is the part why we said generally complied, because OPEGA noted that in one RFP evaluation, the OSPS employee responsible for reviewing the materials did not verify that one of the evaluators had actually completed the required training acknowledgement form. So that was a technical non-compliance there. Overall, we found that the training required for evaluators considered conflicts of interest and appeared to be comprehensive, useful information. Additionally, the requirement to certify having received training is a good practice, we believe, to help assure employees are receiving the necessary education. Now, at the close of the proposal submission period, we're in the middle of page 16, but before the RFP evaluators are allowed to review the proposals, each evaluator is sent a proposal cover sheet for each qualified proposal, along with an agreement and disclosure statement form to sign. We've included this form in Appendix G if you wanted to take a look at it at some point. It requires the evaluators, as we say in that blue box there, to disclose any affiliation or relationship that they have in connection with a bidder. Certify that neither they nor any member of their immediate family members have a personal or financial interest, direct or indirect, in the bidder's proposals. Certify that they have not advised, consulted with, or assisted any bidder in preparation for the proposal. Certify they understand that the evaluation process must be conducted in an impartial manner, and agree to hold confidential all information related to the contents of the RFPs until such time as it is formally released publicly. In all RFP evaluations that we reviewed, there was evidence that all members of the agency evaluation team signed an agreement certifying that they do not have any conflicts of interest. We found one example where the former OCP director, this is not Director Hudak, disclosed a former professional relationship with a bidder on the agreement disclosure form. You'll see in footnote 38, the then director, not Mr. Hudak, noted that a bidder had been his employee at a different organization for a 9-month period, approximately 5 years prior to the RFP evaluation. So there's disclosure there. Oh, yeah.
If the committee would look at page 45, which is Appendix G, staff's agreement and disclosure statement. This is what someone has to sign. There's a paragraph, the second full paragraph. Neither I nor any member of my immediate family have a personal or financial interest, direct or indirect, in the bidders whose proposals I will be reviewing. Interest may include, but is not limited to, current or former ownership in the bidder's company, current or former board membership, current or former employment with the bidder, current or former personal contractual relationship with the bidder, example, paid consultant, and or current or former relationship to a bidder's official which could reasonably be construed to constitute a conflict of interest. In a parenthetical statement, personal relationships may be perceived by the public as a potential conflict of interest. That is what people are signing, even though that's broader than the law. This is
If-
what people are attesting to
If you are on the evaluation team.
on the evaluation team.
And I just want to be clear, Director Hudak was not on the evaluation team for the contract. He had a role, don't get me wrong.
I understand
Yeah.
this is beyond the Director Hudak. This is just about
Yeah.
how this is listed for anyone on the
Yes.
evaluation team.
Yes.
So I want to make it clear that my comments don't always have something to do with the subject, the person at hand. It has to do
Understood.
with the process.
Thank you.
Thank you.
Um, So.
We are almost there.
Yeah,
We're on page
we're
17 now.
we're getting
correct?
there.
Yep.
So there is something called a procurement justification form, which is also a point along the road where there is an opportunity to have a little bit of a documentation on this. Once the agency and successful bidder have negotiated and executed the contract in question, the agency submits the contract to State Procurement Services for final approval along with a procurement justification form. The agency must also submit a procurement justification form to State Procurement Services when the agency is requesting a contract amendment that includes changes in the contract scope of work or dollar amount if 10,000 or more. In July 2024, OSPS added a new section to this form requiring the signatory to certify that they understood and acknowledged Maine's conflict of interest statutes as seen on the following section from the PJF. And you see here, this is a relatively recent addition for contracts writ large. Maine law contains conflict of interest statutes directed to state departments and state officers and employees generally. And there's a place where they are to affirmatively check the requesting department signatory understands and acknowledges Maine's conflict of interest statutes. When required, we saw evidence of the acknowledgement of Maine's conflict of interest statutes by the contract amendment signatories. OPEGA notes that the addition of this checkbox acts as an additional prompt for executive employees to consider potential conflicts of interest and we do consider it an improvement to the form. However, there's always a however. However, it may not cover all executive employees who are involved in the contracting activity. For example, employees who are on a contract amendment negotiation team, but who are not signatories to the contract or the procurement justification form are not required to complete this certification. Additionally, the form is generally not signed until negotiations on the contract terms have already been completed. So again, we're just mentioning if we're in the processes of saying to them, go back and take a look at some of your processes. These may seem minor in the individual, but we're just giving them the laundry list of things that while we went through the review, we'd like you to go back and see if that can be clarified or tightened up or that sort of thing. So I mentioned at the outset in response, while we were doing the review, they responded to us and shared with us a draft conflict of interest policy, which does appear to address these concerns, prompting the authorized signatory to affirm no actual conflict exists at the time of submission of initial contract renewal or amendment. Now, this policy was not in place during the time period we reviewed. I mean, we got it in response to our review. In addition, in August 2025, so just very recently, State Procurement Services revised the conflict of interest section in the procurement justification form to include language, the requesting department's signatory affirms, understands, and acknowledges Maine's conflict of interest statutes and in accordance with those statutes and to the best of their knowledge has determined that no conflict of interest exists. So they've even gone even more detail. So this is an evolving process. There's new policy underway. They're adjusting forms. Now, documenting, this goes to our recommendations. Other than the agreement and disclosure statement and the procurement justification form in which agency staff, this is at the bottom of 17, in which agency staff certifies that they do not have a conflict of interest, State Procurement Services does not require written documentation of potential or actual conflicts of interest which have been identified and disclosed. For example, if agency staff were to raise a potential conflict of interest that was determined not to be disqualifying, that identification and disclosure may not be documented. OPEGA's analysis. Promptly and properly documenting conflict of interest concerns in the procurement process can influence public perception of the relevant circumstances. OPEGA identified the lack of written documentation as an issue. OPEGA reviewed the contracting materials to determine if any disclosure of conflict of interest were made. We noted that there is no State Procurement Services requirement for disclosures of potential or actual conflict of interest to be documented, though it is OCP's expectation that a recusal is made in writing to one supervisor. But remember, that leaves uncovered situations in which someone raises an issue. It's not a worry. Shouldn't you have a record of that as well? OPEGA reviewed the contracting materials, as we said. So a couple of different examples we've had throughout the report. On page 16, we found one example where an RFP evaluator disclosed a former professional relationship with a bidder. I believe this is the former OPEGA director, the former OCP director issue in the footnote. We found one example as described on page 12, where the current OCP director recused himself from that company that has all the letters in it, Cannabis Public Policy Consulting. We saw evidence that current and former directors filed annual financial disclosures as required by statute. We also did take into account that the OCP director, current director, disclosed a prior working relationship with an employee as described on page 9. Now, this is something I want to underline. We do note, however, there's that word again, however, that this email was sent by the OCP director prior to his tenure, and the email itself was not directly related to the metric contract amendment. Again, as noted above, there is no requirement for disclosures of potential conflicts of interest to be documented. We're again presenting this as, we're not saying anything was wrong there, but we're just saying in the future, have a process where those things are readily available, whether they're with the contract file, whether you have one form or you have this form or who keeps it. We'd like more clarity and records and those things. Again, in terms of now look at it from the perspective of bidders, page 18. We also noted that bidders were prompted to consider potential conflicts in the following ways. We observed 3 Cannabis Policy Office solicitations in 2019 and 20, where bidders were required to disclose conflict of interest in their RFP submission. We were told that OCP added this language at their discretion, but that it does not reflect standard OSPS template language. So if the individual sub element is going beyond what State Procurement Services is doing, we just, again, take a look at all of that. Who should be doing what? It's not standard template language. The RFP language that we observed appears to serve as a notice that potential conflicts and their nature must be identified if awarded the contract. OSPS management explained that any potential or perceived conflicts should be disclosed by the bidder and addressed during contract negotiations prior to signing contracts, and that if an agency is unable to adequately mitigate a disclosed or discovered conflict, the agency may then move into negotiations with the next highest scoring bidder. In all RFP submissions reviewed, we saw evidence of bidders certifying a debarment, performance, and non-collusion certification that they had, quote, not entered into a prior understanding, agreement, or connection with any corporation, firm, or person submitting a response for the same services. Proposal is in all respects fair and without collusion or fraud. So they make yet another certification there. After a bidder has been conditionally awarded a contract, the bidder and the state must negotiate the terms of the contract. The current standard contract terms include the provider warrants that no state employee has or will receive any direct or indirect pecuniary interest in or receive or be eligible to receive directly or indirectly any benefit that may be arising from this contract for any employee who participated in any way in the solicitation, award, or administration of the contract. There's that word pecuniary again, and I will submit to you, it means financial, but if I'm wrong, the DAFS folks will come up here and tell you different.
We also have indirect here. which-
Yeah, exactly. Thank you, Senator. The provider may not engage during the period of the contract any executive employee who participated in any way in the solicitation, award, or administration, and there has not been any collusion in the preparation of the proposal. As explained to OPEGA by State Procurement Services, bidder conflict of interest discussions typically occur during contract negotiations when key details related to scope, deliverable, terms and conditions, collaborative vendor relationships, and project personnel are identified and clarified. Requiring bidder conflict of interest disclosures at the RFP submission stage can introduce significant challenges in evaluating and scoring bids, in particular because an accurate evaluation of the conflict concern would likely require follow-up discussion with the bidder, which is not permitted during the evaluation. So what they're saying there's a time for this. It's just not right during the RFP evaluation. This is aligned with best practices. State Procurement Services has worked to strengthen and clarify the conflict of interest contract terms and conditions over the past 2 years. By entering into the contract, State Procurement Services works to ensure that all agencies and vendors are aware that any violations may result in contract termination. Ultimately, as part of this review, DAFS also advised OPEGA that an additional clause has been added to the RFP's template general provision to put vendors on notice that should the RFP result in a contract award, the vendor will be required to disclose in writing and in accordance with Maine conflicts of interest laws, any actual or potential conflicts of interest. Now, resources available to agency staff on questions of conflict of interest. If OCP staff have questions or concerns about potential or actual conflicts in contracting activity, they are encouraged to reach out for guidance. Questions can be elevated as needed to the RFP coordinator, OSPS staff, Office of State Controller, or the Attorney General's office. OSPS indicated that they typically receive between 3 and 6 inquiries a year statewide regarding potential conflicts of interest. However, because of the hybrid nature of procurement, there may be questions and concerns about conflict of interest in contracting that are being managed at the agency level and not brought to State Procurement Services' attention, especially if these questions arise outside of the initial RFP evaluation and award. Ultimately, the process for managing or mitigating potential or actual conflicts of interest depends on where in the contracting activity the agency is when the conflict is identified, as well as the nature of the potential conflict of interest itself. For example, if an RFP evaluator identifies a potential or actual conflict of interest at the beginning of the process and cannot sign the agreement and disclosure statement, the evaluator may simply be removed from the evaluation team and the RFP process may continue. On the other hand, conflicts of interest identified and disclosed during or after the RFP evaluations have begun may require OSPS to assess potential risks to the integrity of the process, discuss this with the agency, and advise the agency whether to continue the RFP or to start the process over. If an actual conflict of interest is identified after a contract has been implemented, the agency and/or OSPS would likely work with the state controller and potentially the Attorney General's office, as such a disclosure could impact the validity of the contract. It is important for agency staff to understand where resources are available throughout procurement-related activities. So we have 2 issues and corresponding recommendations as a result of all of this work, and I will try to go through them smartly for you without skipping over anything. But again, I think I've touched on this. This is page 21. The issue was a lack of clear formal, when you take everything together, a lack of clear formal written policy in state procurement services and in the agency in question here, OCP, outlining how a potential conflict of interest should be disclosed or managed throughout the activities. So we recommend they develop a clear, thorough, formal guidance to agencies on identifying and disclosing potential and actual conflicts of interest. Then disclosures and abstentions from contracting activities due to conflict of interest should be documented. We have varying degrees of discussion in the back and forth in the agency response about documentation. Certain things, as I've mentioned, are not a current requirement that they be documented. These are listed on the next couple pages. Also, we've certainly acknowledge down in the middle of page 23, it's not a statutory requirement to maintain certain documentation. We still think there's value in it. Footnote 40, according to State Procurement Services, most recusal documentation is best retained at the agency level. But in situations in which an agency or State Procurement Services has evaluated a potential conflict and determined none exist, remember, OSPS notes that central documentation would be valuable to record the analysis, to respond to and protect the employee. The reason I mention this, if you have a list, if any of you are working with a list of questions for the department, I mention this, and I'm not trying to be too cute here. I'm just trying to say, while we were working through the process, we got that response at the front saying what it said. When we got the agency response, the formal response at the end, there seems to be a little disagreement within DAFs. And I don't know if it's a disagreement with State Procurement Services and others, but you might ask them, are they saying there is a place for this type of documentation at State Procurement Services or not? So all of that is to say, on the specific area of concern, the statute really, such as it is, controlled the answer. It may cause you to think you would like, for any number of reasons, to revisit that statute in an appropriate forum of your choosing. And then we are able to say they generally followed the processes that they have, but we think more documentation and a documented policy is appropriate.
Thank you, Director. Are there any questions for the Director? Thank you, Director. Are there any questions? Chair recognizes Senator Tucson.
Mr. Director, thank you for your very detailed work on this. I just need you to, if you might, speak a little bit about words really matter in this. And the result we want is beyond a simple determination that there is an actual conflict and disclosure and recusal. There's a middle ground result. We want folks to err on the side of public disclosure in the case of a potential conflict of interest. And then there seems to be another less defined, but has to be less defined because you want people to err on the side of saying what they're concerned about. And that might be, what do we mean by appearance of conflict of interest versus potential versus actual? And I just want to make sure I'm following your analysis when you reach the conclusion on page 21 of the recommendations. These mostly go to, when you use the word potential, which is yet another word in here, you're mostly referencing, you're certainly referencing actual. You're intending to reference perceived. There's an amorphous area there between potential and appearance that's still kind of gray. And I think you've acknowledged that further defining that would not be effective in terms of getting to the result that we're looking for, which is that people will pay really close attention to the possibility, the appearance of conflict, and disclose and recuse and take action based on that appearance, short of some kind of, body of proof that there's a conflict. And so the notion of, I know I'm going in a complete circle here and there's a reason. So an effort to, I love this, your recommendations, which are efforts to further define how we disclose potential, perceived potential and actual. But there is still, we still want to leave room out there in a gray area where there is the appearance or having knowledge of 3 out of 5 facts from someone who's not in the middle of the procurement process might think there's an appearance of conflict. We want to have some conversation about that too. And the value in not trying to clear up all the dusty area is that you want to capture even
Right.
the appearance. What factors might lead you
Right.
to think there's a conflict? Because you want to have that conversation before folks are in the process. Am I following your?
Absolutely.
Okay. All right.
It's just an invitation to the department as a steward and a champion of these issues throughout the state government. Obviously, they are not in a position to necessarily impose every last thing on agencies who have their own authorities, but at the same time, be a source of clarity and explanation. Because as I tried in the most simplest terms to explain earlier in the process, the statutes say what they say. They are what they are. Earlier proposals had, for example, if you just bear with me 1 second, the legislative history is in Appendix F that shows prior efforts to make this more defined would actually have called upon someone to disclose at the beginning of a proceeding any of the following, just affirmatively disclose any close personal relationships with any person, firm, or organization in a proceeding before the agency. Now, again, I'm not questioning the choice not to do this. I'm just saying there have been attempts to consider this historically, and there have been times when it appears from the legislative history that would go too far or that's too restrictive. Again, we think of Maine, we love Maine. It's a small town. There are some industries like this industry that are a number of the folks change roles and move around. And so how do we get the state's business done? So, but I hear you loud and clear that there's areas where there's stuff in the statute, there's stuff that a reasonable person might think is a problem, and then it gets grayer as you go. I just am inviting the department, we are inviting the department to go back and just look at those training materials. If I'm sitting there and I'm an agency official taking the training and I'm trying to understand what is it I'm supposed to be worried about, not to be patronizing whether they're versed in the statute or not. What are we really talking about here? I'm not here to say what statutes should say. It is interesting to me. I have worked in other realms. I've worked in the judicial branch. They have a judicial code. It generally tracks what you said, Senator, about knowledge of the relevant facts. A person questions something or other. Federal level, the appearance standard is defined as with knowledge of an objectively reasonable person with knowledge of the relevant facts would have a question about it.
Senator Dusan.
Yeah.
Thank you, Director.
Thank you, Mr. Director. I think we're on the same
Yeah.
page. I'm trying to take my brain out of the minutia of trying to define
Yeah.
as much as possible
Yeah.
without throwing things we want to consider off the table, and trying to shift myself to what is the result I'm hoping for that
Yeah.
department employee who is developed an expertise in the procurement process.
Yeah.
And what is it that we want to encourage them to do, not discourage them to do.
Right.
And what I want to be careful of is that we are not discouraging an employee who has a general kind of, their tuning fork is vibrating. and they're wondering what's going on here. And so they present that to whatever the next level is, and they look into it. We just don't want that person to ignore their tuning fork because we have so tightly defined actual and potential conflict that they don't want to besmirch someone, unnecessarily. We want them to pose whatever's giving a concern and have it looked into.
Thank you, Senator. Are there any other questions for the director about this very good report that we have received from him and his staff? Seeing none. I will now invite the Commissioner of DAFs, Kirsten Figueroa, to come forward. In the interest of time, I will certainly allow the commissioner to make a statement, to go through the response from the department if she wishes. And if we have a ton of questions, given that we have a full agenda and we have to have a lunch break before we take up the rest of our work, we will certainly extend the invitation again to the commissioner to return for the public hearing and take any further questions, any more detailed questions that we may have. Welcome, Commissioner.
Hi, thank you. I'd like to start by saying.
Please introduce yourself.
Yes.
Thank you.
Yep, thank you. Good afternoon, Senator Hickman, Representative Mastracchio, and members of the Government Oversight Committee. My name is Kirsten Figueroa. I am the Commissioner of the Department of Administrative and Financial Services, and I'm here with our agency's response to OPEGA's review of identification and management of conflicts of interest in procurement at the Office of Cannabis Policy. I'd like to start by saying a couple of things. One is I do have some written comments that I would like to make. I would like to try to fit in a couple of answers to questions that came up while you were asking Director Schleck some questions. I feel like I got some of those, but probably not all of them. And to the point, being able to come back would be great. I also have had an allergic reaction to something, and my throat is scratchy. So if I am clearing my throat and or having to take drinks of water, I just wanted to let you know about that. And then finally, I guess I'd just like to say that there are so many different threads of this conversation. And what I feel like has happened, as with is often the case, is that all of those threads are now thrown up in the air, and you can't fully pull out all the way through its conclusion without getting caught up in another one. And what sometimes happens is that means that things get said and then we don't go back to it because now we got tied onto the blue string that then got tied onto the white string, and we went off on the white string and forgot to finish the blue string. And so I guess I'm saying that for a couple of reasons. One is I will do my best to be comprehensive and to answer the questions. It's possible, though, that we will lose the thread, and I want to be able to come back and finalize that thread without maybe people thinking that I on purpose have done that. So I would like to say that DAFs, including the Office of State Procurement Services and the Office of Cannabis Policy, appreciates OPEGA for its professionalism and thoroughness throughout this review directed by the Government Oversight Committee. To be clear, in our response, DAFs is not saying that we disagree that the facts should be outlined. Our point was that we had outlined what our process had been nearly 3 years ago now, and we're still having the conversation. That's the part. So this review, as you know, focused on how the standards and requirements around the potential or actual conflicts of interest are handled in OCP's contracting activity broadly, and was prompted specifically by the appearance of conflict of interest between OCP Director John Hudak and the state-mandated software company Metric. And OPEGA's findings through an evaluation of statute and policy confirm what DAFS had previously determined has known to be true and has consistently reported that OCP does follow relevant procurement requirements and that Director Hudak does not have a real or apparent conflict of interest in his work negotiating the contract for the state's cannabis inventory tracking system. OPEGA concludes that OCP considered conflicts of interest at several points in its procurement processes and complied generally with current applicable requirements. And OPEGA further concluded that relevant statute was followed. I think that that is a great part of the discussion to happen, is what is the statutory requirement and how are we as executive branch employees who on a day-to-day basis are tasked with executing statute. Like that's what our jobs are. Sometimes 24 hours a day, 7 days a week, our jobs are executing on statute. So in a sense, like that's what we're supposed to be doing all the time. So how we're also supposed to be showing that that's what we're doing all the time is, I think, at question here. And when you get into the conversation about how to document a negative, that starts to get challenging. So somebody years later might determine that if you're looking at a situation now through a lens that is different than it might have been 3 years ago, then you might turn to somebody and say, why didn't you write that down back then? Well, we did the thing, we determined that there wasn't a thing, and we moved on. And what we've learned in the course of that, so that's what I think some of the confusion is about what DAFS does or doesn't think it should document in the future in our report, is that it will be hard to do a one size fits all for one size fits all form for the conversations that we're having. And so I think I would just go to one of those points, which is the law says, or the statute says, financial pecuniary. I mean, it's not DAFS that is reading that. It is the Government Ethics Commission statute says, I mean, we interpret it the way it's been interpreted to be financial or pecuniary. And then the appearance conversation is the reason that the training is more broad is because sometimes people do have the tuning forks tuned in, which is but sometimes they don't, because it's just not like I'm doing my work. Like I'm just here and I'm doing the work and then I look up and somebody says, we have these broader conversations to make you get out of the weeds a bit and think at a different level. And so we say out loud, any conversation, think about anything, think about a relationship, a thing, so that we can have that broader conversation and that we can then say, thank you for bringing that up. That's not what we mean here, but it's good that we had that broader conversation so that everybody in the room could be here. OPEGA concludes that OCP considered conflicts of interest at several points in its procurement processes and complied generally with current applicable requirements and concluded that relevant statute was followed. OPEGA further confirms that Director Hudak was neither a partner of Lewis Koski nor a shareholder in Friedman and Koski or Metric, and that the fact, quote unquote, the facts do not support a conclusion that disclosure by the OCP director of the prior relationship with Lewis Koski or abstention, not participating at all, was required by statute in relation to the Metric contract amendment. End quote. Therefore, he did not have a real or apparent conflict of interest in his work renegotiating the state's contract with Metric. As part of its scope, OPEGA also reviewed the procurement activities related to 5 procurements that occurred in OCP since its inception in 2019. And included in their report a good real-world example of the interplay of state laws and policies governing the procurement process. OPEGA's review makes clear that the OCP employees involved in those contracts considered conflicts of interest at several points in the procurement processes, and therefore were in compliance with existing requirements. OPEGA concluded its review with recommendations of formal conflict of interest documentation and thoughts on centralized reporting. The reality is that there are very few instances where an employee or agency will determine that a conflict of interest exists for an individual whose job's responsibility include procurement activities. Having said that, DAFS is prepared to continue these discussions, including a review of the draft policy and updated forms already prepared by DAFS and shared with OPEGA, as well as the reasoning for relevant conflict of interest evaluation to occur at OSPS on the centralized level or at the agency level, depending on the stage of the contract. It really does matter on what the stage of the contract is. And as to the original scope, though, of how the standards and requirements around potential or actual conflicts of interest are handled in OCP's contracting activity broadly and specifically to the director, my request and sincere hope this morning was that the committee chose to close those matters today. It is time to pierce the manufactured cloud that's been encouraged to swirl around this ethical, skilled, and remarkably competent individuals that we employ and allow them to continue to do their work. It was determined that there was no real or apparent conflict of interest when DAFS evaluated the questions nearly 3 years ago during the director's hiring and renegotiation of the metric contract. That determination of no real or apparent conflict and the components of how we got to that decision and determination have been shared by DAFS, OCP, and the director whenever asked, specifically in response to inaccurate reporting or negative social media campaigns. And it's now been determined that there was no real or apparent conflict of interest by OPEGA's independent findings. Maine state government takes seriously its responsibility and commitment to ensuring the public's trust in our government, beginning with hiring individuals with the skills, experience, and judgment necessary to perform the duties associated with their position. That is by definition going to more than likely include previous interactions with businesses that did the same thing that we're asking them to come to the state and do. Like that is one of the things we look for. What is your experience? How can you talk about these? Components of your work? The collective commitment by all public servants to act appropriately and ethically ensures the highest quality of performance and inspires public confidence in our stewardship of the resources and decision-making entrusted to us. Any allegation of a breach in that trust is taken seriously, and any violation would be addressed appropriately. As I mentioned, executive branch employees are tasked with executing on statute, and the requirements of exactly how and when we are meant to show that we are doing that which we are meant to be doing on a daily basis does get confusing and can get tied up in those threads when one component is pulled out and evaluated. And so we're happy for the evaluation. We're happy to continue to talk to OPEGA about some of our forms, our policies, like I said, when and where they should be held. But one of the conversations that we had, and I think is a little bit confusing, is that we said, yes, we do agree that we need to be a little bit more, that we need to have more formality around something. At the same time saying, however, we don't want to overly formalize something. So if a person has come forward and said, I do have a relationship with a vendor that I think might be a bidder, they're taken out of the process then. Why would we document that and have this become a record of something that they were bringing it up to recuse and excuse themselves. And so we did that. And so to have there be a formal record of all those conversations that may involve relationships or personal health information or something else, just not having to necessarily prove something that didn't end up being a thing because we stopped it from being a thing when we were having the discussions. So those are some of the real life conversations that I think when you're reviewing something from outside, there's not, the consideration isn't necessarily the hundreds of thousands of other things that are also happening at that time. And so I say that. But unfounded criticisms of state employees have a real and negative impact on the morale of our workforce and make it much more difficult to recruit and retain supremely qualified individuals who have the subject matter expertise and practical skills, experience, and judgment necessary to perform their jobs with the high level of competence that the public deserves and expects. And unfounded criticisms also erode that public trust without cause. I want to just, I think I've mentioned, the only other thing that I want to mention was, oh, no, sorry, I was just looking at my notes about speaking in the difference of training and making those conversations a little bit more robust. The inconsistency of what we meant by document versus what I think was interpreted in our reading and in our response document. I'll go back and read that and we can clarify that at our next meeting. And then again, not saying that it wasn't worth this to document, saying that it had been done and how we might be able to prevent in the future a topic being talked about as if it were real or still unsettled for nearly 3 years now is a challenge. So thank you for the opportunity today.
Thank you, Commissioner. Are there any questions at this time from the committee? The chair recognizes Representative Perkins.
Thank you, Mr. Chairman. Thank you, Commissioner. So I'm trying to understand this dual procurement process a little more generally, and I'm trying not to pull on one of these threads too far. But so I noticed in the report that the director gave us, he mentioned the IT procurement director. I'm assuming that person is part of OSPS?
IT procurement?
Yeah.
Yes.
So how many different procurement directors are in OSPS?
We have one director of procurement of the big office. We do have an IT procurement section, specifically because technology procurements are so much more complicated and involve usually data sharing or system requirements. And so if it has a data component, it goes through a technology component, it goes through the technology procurement group, which is housed inside Office of State Procurement.
Okay, and I can understand that, but there isn't like a separate director or subdirector for every different agency. That you don't have like one for IT and then one for an example, maybe like DEP and another one for vehicles and stuff like that. You just have one director and then one for IT.
We have a subsection specifically for IT so that mostly because they are more complicated,
Right.
that they don't kind of clog the procurement system down by having a technology one get in front of 3 non-technology
Right.
ones. Yeah.
But you don't have a whole office of just directors.
No.
Okay, that's what I was trying to understand. Okay,
Okay.
thank you.
Yep. I'm sorry if I didn't understand the question.
Thank you, Representative. Are there any other questions from the committee?
And I think like I said, we'll go back and listen and some of the questions that came up and maybe can better clarify.
And we may have some written for you
Perfect.
before
That
the
would
public
also
hearing,
be,
so that you can, if we do, we can, if members do, we may put those in writing for you as well, based on what you've already heard today.
that'd be,
Because
that'd be
there is a
very
couple other
helpful.
things here. Thank you, Commissioner. And I just wanted to say, as chair of that other committee, when the director was hired, industry participants came to me over and over and over again and said, here's why we think this is the wrong person. And I would say, it's not up to us to decide that. Here's all this evidence of what could be a conflict of interest. And I would say, show me the evidence. So I just want to say that on mic, that as far as who DAF's hired to do this position was something that the committee members always accepted. It was the industry that had a problem with it. And without any evidence of a conflict of interest or financial gain from any prior relationships that the director may have had, it was a non-starter. The Veterans and Legal Affairs Committee doesn't have the staff, the time, or the energy to look into any of that. So it wasn't until this letter came to our committee to look at where I thought, if there's anything, it will be found. If there isn't, settled. That part is done. Now, there may be critiques about the way the Office of Cannabis Policy runs, but that's separate from who's running the Office of Cannabis Policy. So I just wanted to make it very clear here. I never had any issue with who you hired based upon experience and point of view. And so I'm glad that we could have an independent agency of office of our government that does this work, put an end to that part of the conversation.
I agree with you. That would be great if this were the end of that
Well, I
conversation.
mean, we can't control what other people say or do in the
Well,
world.
I think
but
that
for
the
us,
way
we
we
can.
respond out loud when the question comes up, I think that was more my point, is that this conversation has been brought up a number of times. It was brought up by the same representative at the beginning of 2024, just like it was brought up recently in 2025. And DAFS has consistently responded with what we did and what we said, and that there was no financial and pecuniary interest as required. And I think that going back and looking like Opega did at the previous conversation about the appearance, it was a very robust conversation by the legislature, because we all are public servants and we all have interests that we are meant to represent. And how do we make sure that we can be very clear with how we're doing that as forthrightly as possible? And so I also agree with you that I feel like the question has been asked and answered, which is why I was kind of hoping that at least the ongoing conversation about whether the statute needs to be changed or our forms need to be updated, that feels like an ongoing conversation that we can continue to have. Is there an opportunity for us to stop the other part of the conversation today based on what we know and not bring it to public hearing and not bring it to the next thing that comes, right? It's just another several months of a process was why I had hoped to have some time in front of you today.
Yep.
And had hoped that we could peel those two things off, because the answers seem very clear.
Well, as
that-
you know,
that there
with
wasn't.
the reporting process, we will have a public hearing that will be noticed at least 2 weeks in advance, according to statute. And sometimes people show up for those public hearings and sometimes they don't. And so we have no idea what will come through the door when we have the public hearing on this report. So I don't think that anyone on this committee can safely say that no one from the world will bring this up again. But we did what we thought was best as a unanimous vote of this committee, was to look into this and see if there's anything in the broader procurement process that the committee also determined at the end of the last legislature to look at. What can we find out about how we do this to make it better and to give the public and industry participants the perception and clarity that everything is above board to the extent that we've looked at it.
Yeah.
So that's what this whole process is about. It was, from this committee's point of view, it wasn't about a singular person. It was about an entire process in a very new department that would bring us answers or maybe ask us more questions about procurement writ large in the state of Maine.
I mean, the scope of it was whether OCP followed the regulations, and in particular, whether there was a conflict. That was right. Started because of whether there was a conflict with the director. The extension of whether that applies or does, needs to change something in procurement, it feels separate. Like that is, the scope feels like it's been answered. The surrounding threads, if you will, of that white thread of scope has been answered, but there are lots of strings and other threads, I agree, that are attached to that. And that was, and I think we probably do know to a degree how that public hearing is going to go. And again, I implore in whatever way that I am allowed to do that from here without overstepping something, that it not become another opportunity to do that which is pretty consistent towards an individual that has brought his expertise, has continued to stay in a job that is defined by statute that he executes on daily with a team behind him. I have a responsibility as the commissioner of the Department of HR that I need to protect the employees that are coming and doing their jobs every day. We are, some of us, a very tiny, tiny few, including myself, not including Director Hudak, are political. But most employees of the state government are not political positions. They are people who come to work every day doing the best that they can in a structure that is threadful. Threadful. That's what I'm going to say. Threadful. And so I implore you on that as to how the public hearing on this report would be structured, and appreciate that.
The chair recognizes Representative Matlack.
Thank you, Mr. Chair. Nice to see you again, Commissioner. I don't believe you were here earlier when it was announced that we cannot vote on anything today. I would like to vote on this and make it go away, but we cannot because Senator Bennett is no longer a member of a political party and we have to replace him.
No, I'm sorry. I did not hear that.
Yeah, so I just wanted to explain to you why we're not going to go anyplace today, as much as I wish we could.
I
And
appreciate
even if he were here, the process of a report is we have a public hearing. And then the committee at that time or any time in the future may vote to endorse in part or not endorse the report as it's been released to the public. And so our work is not done on this report. And that is just the nature of the statute as well that we must comply with. Representative Stracchio, did you want to say something?
Thank you, Mr. Chair. I just want to thank you for coming. I appreciate the issues around this. I think conflicts of interest, having dealt with it at the local level and have it in our charter. We not only have it in our charter, a whole enumeration of what conflict of interest is, and then we have state law is in our rules of procedure because that happened to be a really, really big issue in our community before we became a town council and before we became a city. So I appreciate that. And I also know that it's far reaching into many areas. So I think we will have a public hearing that will be just on this report. I think that it will, I would not want it to delve any deeper than what we are talking about in this report. And I appreciate what you're saying, and I am with you on that. So thank you.
Chair recognizes Senator Dusan.
I also am concerned about the direction that a hearing on this report might take with regard to the specific instance of Director Hudak. And that's because the allegations are repeated in OPEGA's conclusion. They're repeated in a way that says he didn't do anything, or that perhaps he did more than he would have been required to do by the conflict of interest statutes, by disclosing and recusing, despite that there was no actual conflict, and barely, I would argue, it looks like there wasn't even potential conflict, but he disclosed and recused out of respect for the perception of conflict. So I think he over-complied with the essence and intention of the conflict of interest rules. And that is brought out on page 12 by our director, and I really appreciate that. But I would hope that as we go to the hearing process, we would find a way to make sure that part of the report is emphasized, because this particular state worker has been besmirched and besmirched and besmirched again in our public proceedings, both in written documents and in hearings before two legislative bodies, before two legislative committees. And that makes it pretty darn hard to recruit talented people to state service and retain them. So I think I just felt the need to say that if I'm reading all this correctly, it seems that the process worked. There are recommendations to tweak it in other ways to make sure it continues to work. But the every time it's brought up, the context is the precipitating allegation. And I just hope that we will consistently highlight that in terms of the precipitating allegation, there was not bad behavior, bad intent, and in fact, there was over compliance.
Any other questions or comments from the committee before we take our lunch break and return to complete the rest of our agenda? For those who are here, we will hear from the state auditor, and then we'll have two presentations and the director's report. So it is now, and thank you, Commissioner, for being here today. Representative Mastracchio?
Can I just talk to you for a second?
Yes. So the committee will be at ease until 1:45.